everybody can hear me. We're going to start with the first plenary panel. Let's hope that the technical issues will be resolved anytime soon, but this shouldn't concern us too much for right now, because here we have a great group of people already together for this panel. Now, the theme of the panel is navigating multiplicity. It starts from the idea that multiplicity of law can be thought of as a multiplicity of legal and other norms, but the relation of the norms depends on the way in which they are used and connected by actors, litigants, courts, governments, norm addressees, etc. Now, this panel is really interested in understanding how do actors navigate multiplicity? How do they make sense of it? How do they position themselves towards it? And how is this navigating different from what we're used to among legal actors? How does multiplicity change the legal game here? And for this, we've on the program 4 really outstanding speakers, all coming from different backgrounds and having engaged with that question of navigating in their work quite extensively. So far, I think we're still missing Miguel. So we start anyhow. That's kind of one of the joys of the online environment, that you never know if somebody is around until they're actually connecting, and you can't simply grab them by the hand and say, well, now you're on your panel. But in any event, we have, so for the moment, 3 really outstanding speakers whom I'm going to introduce just very briefly before we get started, because we don't want to lose too much time by introductions. The first is Julia Eckert, and maybe the panelists could switch on their videos so we can at least see each other. Julia Eckert holds the chair for political anthropology at the Institute for Social Anthropology at the University of Bern in Switzerland. Many will know her work, especially perhaps, and especially pertinent to what we're doing here today, is her book on law against the state, which is focused on the juridification of protest and the globalization of transnational legal norms. Very inspiring, and especially kind of very different take, really, and kind of starting point than what international lawyers normally use. And I found this enormously helpful, really, for trying to think about, especially the actors and the context in which these actors operate. Our second speaker, Balakrishnan Rajagopal, he's an associate professor of law and development at MIT, and he's also the UN Special Rapporteur on the right to adequate housing. Many of you will know him from his work in the TWAIL context, especially from his work on international law from below, where he is really trying to understand how actors that are disfavored can make international law work or engage with international law in order to make it work better for their aims in the limitations that they are. And our third speaker, Surabhi Ranganathan, is a university senior lecturer in law at the University of Cambridge. And she published a few years ago a book that impressed me much, really, Strategically Created Treaty Conflicts and the Politics of International Law. And she has ever since kind of tried to understand the politics behind international lawmaking, the global commons. And I think from that perspective has a lot to say to us. We start with Julia, and I hand over the floor to you.
Yeah, thanks, Nico. Thanks for the introduction. Thanks for inviting me, and for engaging in this whole conversation, which of course is very important for legal anthropology as well. And maybe when the first question really that came to me when being asked to think about navigating multiplicity was, okay, when, from my perspective in legal anthropology, when does multiplicity actually exist and for whom? And this is a little bit not to question the sort of assessment that you and Hannah introduced, and saying, well, we are having a situation of multiplicity. It is rather that now that we are acknowledging in different disciplines, that systematicity and unitariness are a kind of narrative and not a given. We should not assume that multiplicity is simply a given, but need to explore when, in what form, and for whom it exists. So I'm taking very much an actor-centered perspective in my considerations, and one that also tries to look at least at how power asymmetries are affected by it, and also shape the possibilities to actually navigate multiplicity and thereby bring it into existence. I mean, saying something like multiplicity exists only when it is navigated by actors. I think maybe it also needs to be said that I'm speaking also at the same time to a non-existing debate in legal anthropology, where there is a somewhat of a communication gap between those who explore pluralism and multiplicity and others who consider law as such, as a sort of Kafkaesque Leviathan or a Benjaminian force. So there is a sort of, and to bring those into conversation would be, for me in legal anthropology, also quite an important endeavor. So I came thinking about my research, also my recent research on legal accountability of multinational corporations, to three types of navigating multiplicity. Namely, firstly, the denial or rejection of multiplicity, then the novel forms and novel modes of what once was called forum shopping, which I would now use the term singularization for, and I will speak about that. And thirdly, the attempts to create relational coherence, what I've called relational coherence. Rejection and denial seem pretty straightforward, and so I won't go into that. I think anyway that we will hear in the course of these 3 days about other forms, but also more about these forms that I'm addressing here. So maybe let me start more with what I would like to call singularization. It seems to me that the current constellations of multiplicity increase the possibilities for some actors to shop for the most beneficial legal forum and to pick and choose the most beneficial norms for their concerns. And it seems to me that this such pick and choose introduces a new logic of law that I've called singularization. By that I mean that cases cease to be treated as instances of more general problems to which a norm governing that problem can be applied. And there could be conflicts about which norms is the right norm to govern that case, but rather that issues are treated as singular conflicts between particular actors in specific situations and are dealt with as such singular events. Such singularization is furthered by the tribunalization of law, particularly private law, of course, commercial law, investment law, and contract law, in as much as there the role of judges gains a new character and is sort of redefined as serving as mediators in forums in which the norms to be applied are chosen or even defined by the participants. And the norms referred to are above all tools of mediation. In our exploration, as far as possible, of arbitration, forums, out-of-court settlements, and ADR, we found that they all focus on the unique circumstances of single cases and the unique constellation of parties concerned, and aim at an agreement between those involved rather than finding solutions according to more general norms. And even when the procedures and also the people conducting such ADR are increasingly professionalized and procedurally standardized, they are highly flexible in terms of the norms applied to the conflicts in question. It is the participants in an arbitration who agree on arbitral rules to be applied, as well as on procedural issues. Moreover, they are often private in several senses of the term, as content, process, and outcome of such tribunalized conflict resolution often carry a secrecy clause. So singularization proceeds in several ways: the avoidance of a judgment about fault relating the case to a general norm, the private agreement between the parties involved, and secrecy. And thereby they cannot serve as a precedent, and any more general norm development is cut short. The distancing, I think that's your word, Nico, entailed in such singularization is not only preserves or increases the distance between different bodies of law or amongst different systems of law, rather it creates a distance between cases, so that cases become unique, singular. It is thus a specific form of distancing, possibly the most radical one, inasmuch as singularization does not preserve an earlier distance, but introduces a new logic. Which concerns, I think, but I will wait for your assessment here, the whole logic of law. It makes the development, I think that's a concern of Nico as well, of tertiary norms unnecessary because it circumvents rather than regulates the conflicts of norms. Anthropology often celebrated such custom-made conflict regulation for its accessibility, its attention to circumstance, and the potential for restoration that they entail, rather than, for example, retribution. Often it was also considered much closer to other norms, traditional legal orders and so on. But in my research, I found at several scales that is both at very local small case scale conflict resolution, as well as in larger cases that we looked in recently in between social movements and multinational cooperation. On the side of the weaker parties, a lot of skepticism whether they could actually negotiate compromises in their favor in such settings. As one president of a Bombay slum once said, a compromise gives me only half my right. And without precedents, of course, the means of negotiation are further curtailed. And because of this, I think this is one of the motors of the narrative of some sort of systematicity to live on, albeit from different corners and sides. And it is not systematicity as such, but what I have called a relational coherence of law. In many social struggles that evoke all sorts of norms, irrespective of their possibly distinct provenance and willfully ignoring potential inconsistency, they create new normative meanings. And this is the type of navigation that I identify here, the creation of such relation of meanings. Again, I have observed such struggles or propositions of relational meaning on different scales, both at a very local scale where it is state legal norms from state legal systems, religious law, as well as other customary or unnamed normative systems anchored in everyday practice and dispute resolution. And at the other scale of transnational litigation, where social movements, amicus curiae, and others mobilize norms from diverse bodies of law and sometimes interpret them in the light of alternative normative systems not codified anywhere. Here, particularly in our case, it was the notion of buen vivir, which of course by now is included in the Ecuadorian constitution. So they connected their norms from about biodiversity, national laws on social and economic rights, international conventions on indigenous rights, resolutions on states' obligations to take measures preventing further climate change. Or an example that Kibet von Bender-Beckmann pointed to, the negotiations in the WTO about anti-retroviral drugs that connected trade law, intellectual property rights, and a human right to health. So in a way, this this specific navigation of creation, the creation of a relational coherence results from some, or quite often, desperate attempts to make use of any norm that might provide claims with normative justification or even legal argument. Basically, it's turning normative justification into legal argument, which creates this relational coherence. So what happens here is not that a systematicity is created, but it's a transsystemic relation of meaning that the proponents propose to be necessary and inseparable. There is a suggestion that any law needs to be, or any norm needs to cohere to a larger idea of legal coherence. They thus not only bring into closer proximity norms originating in different legal systems or bodies of law, they also challenge the boundaries that current law establishes along chains of distributed agency and around different fields of practice and interaction. So, I just quickly want to come back to the question that I started out with, namely, who can actually actualize multiplicity in these manners and how, so that it needs to be navigated also by others. And here I think I would like to come back to the notion of translation that Sally Mary, in whose honor we meet here, employed, and who pointed to the translators, particularly within courts, tribunals, political arenas, and policy forums, where some suggestions of normative regulations gain traction and others disappear from the debate, thereby also pointing to the power asymmetries of navigation or in navigation. So there are always those who are prohibited from navigation, who can neither shop for the forum most beneficial to them, nor make the attempts to create strong relations between norms heard audible, and for whom therefore there is no multiplicity. The silencing of poorly integrated and less vociferous, less charismatic contestations is in itself one of the aspects of navigating multiplicity, I would say. Yes, I think I can conclude with that here, and I'm really looking forward to Balakrishnan's and Surabhi's inputs.
Thank you so much, Julia. Great, kind of that got us going already with a number of really important themes and queries, and also kind of observations about the very intricate combination of power and accessibility of multiplicity and the possibility of actualizing, as you call it. Balakrishnan, I hand it over to you. Since I'm curious to see kind of how your take is on those questions, the possibilities, the differential possibilities of different actors to use the multiple normativities that they have available.
Thank you, Nico, for inviting me, and it's a great group. I wish we had actually been in Berlin, as you said, but hopefully normalcy will return soon. In fact, certainly we are living through some extraordinary and strange times, not just the pandemic, but I happen to live in Washington, D.C., where one could say that we are kind of in the eye of the storm, especially given everything that is going on. Apologies, there is a phone ringing in the background, so let me just mute for 1 second.
Bala, you have to unmute yourself.
Yes, there we are. I'm back. So yeah, like I said, certainly some interesting, strange times, and so it's a bit of a time of distraction as well. Some of my remarks today are sort of my initial sort of reflections on the themes of multiplicity, and having looked at some of the abstracts and papers as well. As I think many of you know, most of my work has actually been from the perspective of multiplicity. Looked at it's been a very actor-centered sort of perspective. It's certainly tried to look at the way different actors have engaged with multiplicity, in particular, how social movements have engaged with the question of multiplicity, how they have navigated or attempted to navigate the relationship between different legal fields over the years. So some of what I'm going to say is kind of drawn on some of the work that I've done, but also on the assessment of how I see the trends emerging now, as we see. Now, of course, you know, it's not anything new for me to sort of point to the fact that multiplicity, of course, has different meanings, even among us as international lawyers and those of us who work on transnational law. But, you know, in general, you could sort of look at two kinds of multiplicity that exist in law. And the first one, of course, is the more familiar one relating to horizontal multiplicity that relates to the relationship between different regimes of law in international law, for example, between different areas of international law, which in turn leads to questions of overlapping and forum shopping and all the other matters in private law, but also in different kinds of fora that exist even within the same area of law. Like, for example, human rights law has multiple areas with different levels of normativity in terms of the specificity of the human rights norms that particular actors in particular social movements can engage with or appeal to or rely on or use as part of their engagements with international law. Of course, you know, the concern or the focus on horizontal regimes of law is quite well established in international law from, of course, the work on fragmentation of international law to the more recent sort of work that has actually tried to argue that despite fragmentation or appearance of fragmentation, there is in fact a kind of an internal logic to it, or regime harmonization of some form that actually exists in international law. But I know, of course, we are also familiar with not just horizontal regimes of law or horizontal multiplicity of law, but also a kind of the more traditional or longer form of multiplicity that we are aware of course, is the conventional vertical multiplicity. The vertical multiplicity, of course, exists more conventionally within a Westphalian sovereign order, consisting of the relationship between, different forms of legal orders, right from the early days of legal anthropology, identifying indigenous legal orders, for example, or substate or private or other networks of legal governance, which, as Nico said in the opening remarks, often were seen as existing side by side, a kind of a loosely, coordinated, but often coexisting side by side. But at the same time, within the logic of a sovereign legal control or supervision. And so it is in that loose sense that I use the term vertical regimes. What I generally see in recent years, in particular around the world, but particularly in the global south, is a general trend towards the constriction of vertical regimes, leading to a kind of a form of sovereign centralization, while horizontal regimes, of course, continue to persist and, if anything, pluralize more. But they are certainly impacted by this form of sovereign centralization as well. And if we look at how social movements are trying to navigate these forms of loss multiplicity, both the horizontal, multiplicity as well as the vertical one, what one, on the face of it, what one could say is that the main barriers to what you might call a successful navigation might actually exist more and more at the level of at national level, but not so much at the international level. As I said, again, on the face of it, they appear to have more success in navigating multiplicity of law to their in their interests globally. One could see both in the examples of movements trying to generate new norms at the global level. Look at the recent work of the Human Rights Council on the drafting of the Declaration on the Rights of Peasants, for example, very much driven by the work of a movement like Via Campesina, or the use of foreign courts for the enforcement of civil judgments, or for recovery of for civil recovery for unjust enrichment or other forms of civil remedies that one sees when you see courts in Southeast Asian countries like Cambodia, movements from those countries relying on courts in other countries, both countries in the global south like Thailand, or Western courts, countries and Western governments, states such as the United Kingdom for appealing to different modes of law or levels or scales of law. Nationally, I would say that there appear to be far more constraints or barriers. The trend towards sovereign centralization is very much sort of illustrated by the emergence of the judicialization of politics within many countries, and the rise of the courts and the judiciary as an organ of governance, essentially not a dispute resolution mechanism or an instrument that is supposed to assure the compliance with substantive notions of justice, but as an extension of the order of the state, essentially sharing the similar ideologies and biases of the state itself. And this in turn, the rise of judicial, governance as I've referred to in some of my work before. And the judicialization of politics is in turn sort of aided by the rise of particular forms of nationalism, including the rise of, religious and ethnic, of course, nationalism, which are very much in the news, but if you look at the last 20, 25 years period, if not longer, the rise of a particular kind of developmental nationalism, which is based on a particular notion of the role of the state as the kind of the main sort of instrument in consolidating the issues and the mechanisms of governance to ensure, for example, faster strategies to ensure faster tracks towards economic growth. These put together have, I would say, sort of led to the kind of sovereign centralization that one sees around the world. Let me turn to some remarks on the rise of course, a new global South, a counter-hegemonic global South of states and social movements, which have been critical during this last 2 to 3 decades, certainly since the emergence of the most vigorous or robust period of international institutional or legal regime making since the 90s. If you look at how they have actually dealt with the question of multiplicity and fragmentation, this new global South, and how they've navigated the multiplicity of law during this period. I think probably the assessment that one can offer is that the new global South has actively sought out a terrain of counter-hegemonic political possibilities, while not necessarily showing that they're able to, for example, offer a more systemic coordination or come up with, in the sense in which, for example, Julia was talking about the relational coherence or singularization. It's more a coexistence of contradictions that one sees around the world. But in turn, the coexistence of contradictions is not necessarily a bad thing in the sense in which these different engagements of the global South has been able to take advantage of some of these contradictions at particular moments, depending on whether there's actually a particular coalition of interest that allows for a enactment of what I and many other scholars have been calling as counter-hegemonic possibilities. As examples, of these, you could look at the diffusion of Southern models of laws and best practices across different scales, especially of social policy, which is central to economic and social rights. Think of conditional cash transfers in Mexico and Brazil, or the spread of the right to information idea from India, or participatory budgeting in Brazil, which are originally ideas from the South, to the gradual spreading of the idea across the rest of the South, but also to the North. You could also look at the rise of social movements as moments for the enactment of counter-hegemonic politics, particularly visible in the realm of international economic governance, with the moments such as, of course, Seattle protests in 1999 against the WTO, to the World Social Forum mobilizations in the 2000s to protest against the G8 and G20, World Bank, IMF, WTO meetings, the global movements against intellectual property and pharma. One example that Julia referred to as well, the appeal to human rights norms, for example, in the realm of trade by movements, both at the national level within courts, but also at the global level, including at the WTO meetings, cementing, for example, the move towards new instruments in international trade, such as the Doha Declaration on the right to on health. Global movements against corporate control of food and water and for local sovereignty, and the rise of the popular movements as for change. in multiple ways, which have had a very significant impact on the way in which domestic legal orders regulating banking or corporations or others have been sought to be remodified. Think of the impact of the post 2008 Occupy movement within legal regimes and on legal interpretation. Uh, we can also look at new linkages between movements in the South and the North that have emerged as a critical part of these recent years. For example, ongoing engagements between movements such as Black Lives Matter or Me Too movements or movement of indigenous people around Standing Rock with movements of others who around the world, which actually provide new languages and vocabulary, which appeal to different legal orders or different articulation of legal norms, whether or not they're formally recognized by international lawyers themselves as legal norms. And we see that happening with groups working across different areas. For example, coalitions of groups working with the urban poor. You think of relationship or links between the Asian Coalition of Housing Rights and Slum Dwellers International, and movements on land, as I referred to earlier, links between movements such as Via Campesina, which has adopted a fairly a proactive position on engaging with international legal order, particularly through the issue of food sovereignty and food security, but extending to questions of land in links with other farmers groups as well. And many of these movements or links between social movements in the South and the North are undergirded by or in coalition with states, selective states in the South. For example, in agricultural negotiations on WTO rounds, you saw particular coalitions of southern states aligning themselves with social movements. For example, during the Cancun rounds, or sometimes with friendly states in the global North as well. So the coalitions are shifting in the terrain of what this counter-hegemonic politics is about, but one sees linkages and engagements that exist between different actors as they navigate this very complex and contradictory terrain that we call multiplicity of law. Of course, finally, we also see a major influence by movements on new lawmaking and global governance, as I said, not just in the enactment of new declarations and treaties, like the Declaration of the Rights of Persons, but also influencing the implementation of international instruments, from the Paris Climate Change Treaty to the human rights treaties and standards, from the new African Treaty on Internal Displacement to Disability Rights Treaty to the Cluster Munitions Convention. As I look more closely at the type of actors who are driving the language of possibility and change, one sees these forms of networks, these interrelationship between Southern movements and Northern movements, and the relationship with particular states inserted in the middle. So let me, on that note, just conclude by saying that the rise of this South, I think, also provides opportunities to challenge some of the power structure of international law embedded in the rules, institutions, and organizations of international legal doctrines and practice. But it is by no means it is obvious that will happen because of the multiplicity of law by itself. Instead, it is by seeking a counter-hegemonic contestation that movements seem to navigate the multiplicity of law. And this multiplicity is in turn, of course, constricted and subjected to the increasing sovereign centralization that one sees around the world, characterized most particularly by the rise of the judicialization of politics. So let me conclude on that note. Thank you.
Thanks so much, Balakrishnan. Really fascinating survey of different engagements, attempts, actors, and sites in which this multiplicity is actualized, and somewhat a different note really to the multiplicity theme than Julia's before, where Julia was more maybe skeptical about the possibilities. Now here kind of you bring out some opportunities, especially for counter-hegemonic action. We're going to come back to that potential contrast, or kind of we can try to illuminate that contrast a little bit more. But now we turn to Surabhi, who has also thought a lot about power and is going to take us onto her journey, kind of a certain disoriented journey initially, kind of from what I take from her think piece, but taking us into very, very interesting territory. Surabhi, the floor is yours.
Thank you so much, Nico, and thank you to you and Hannah for the invitation and for organizing this wonderful event. I'm also really delighted to be on a panel with Julia Eckert and Balakrishnan Rajgopal, and really, I'm delighted. I mean, also slightly overawed to be following what were two very rich set of reflections. I think what I'm going to do is something that is really in the same ballpark as both, but sort of moves the conversation away a little bit from actors to patterns. And what I'm trying to suggest in my think piece and in my remarks now is somewhere at the crossroads of what the two speakers were saying. So I agree with Balakrishnan about the ways in which actors navigating, international law, navigating its multiplicity, etc., might create opportunities for contesting its hegemony. But then we have to think about what international law itself does with the potential for contestation, or what it does with these counter-hegemonic moments, the ways in which it tries to fold these moments back into what seem to me it's sort of inexorable logics. And these are, of course, logics that Julia has spoken about, and I know at least I know from having read Professor Chimney's paper that he'll be talking about these as well. So the idea of my think piece was really to say, well, let's take a kind of walking tour around the sites of international law. So some of the cases, some of the news stories, some of the writings that sort of regularly drop on our desks as international lawyers, and think about the ways in which what they reveal about how international law engages with moments of encounters between different kinds of legalities. And I visit three kinds of sites here, in each case to suggest that what is really important is to think about the role that power in terms of political power in terms of material resources, power in terms of control over systems of knowledge production, the ways in which this kind of power shapes opportunities that actors have or have not to navigate with international law's multiplicities. In many cases, you find what happens is that the actor gets subsumed or drowned in the very act of engaging or trying to navigate the confluence of many legalities. In other cases, you find that actually the confluence of many legalities opens up opportunities for an actor to navigate successfully. So the three kinds of sites I visit are firstly, where international law encounters other legalities. And these could include indigenous legalities, which have been talked about already, the legalities in terms of the pre-colonial legal systems of Asia and Africa that were encountered in the process of colonization, and legalities that sort of emerge from ecocentric normative orders. In each case, and here following the work of many third world and critical legal scholars, I suggest that the common pattern that you see, despite some differences in specific instances, but the common pattern that you see is one of subsumption. What you see happening is that the other order inevitably tends to give away before international law, and major concessions are exacted from the actors that are seeking to navigate at the juxtaposition of this international law and this other legality. So what you find is that indigenous worlds, pre-colonial worlds, ecocentric worlds are remade and thereafter become capable only of symbolic recognition within international law. They are recognized through performances such as of standing on unceded land, but they don't. This is with respect to indigenous legalities, but they don't really amount to generating a return of that land. Similarly, they amount to performances of apologizing for colonialism, but not again in terms of providing for reparations for it. Sometimes, as with ecocentric normative orders, what you see is that these orders might produce a kind of qualification of international law's own logics in terms of filtering into it additional procedures. So procedures of consent, procedures of participation for those affected by extractive activities, processes that require sort of environmental impact assessments or other safeguards to ensure that whatever extraction takes place might take place in a better way. But the cost of these qualifications is, of course, the acceptance of extractive logics that are already coded into international law. So in short, of course, I mean, you can tell lots of specific stories about things being made better through the actions of, through these encounters between international law and some of these other legalities, but you can't, it's rare to find stories of international law being unraveled or significantly remade in its logics or in its priorities by the actions of these other legalities. And the major example that I discuss in the paper in this context, I won't elaborate on that now, but I'd be happy to discuss it offline with anyone interested, is of course seabed mining, an activity that hasn't actually taken off in a material sense, but its political economy has been set in stone for the last 40 years and seems impossible to unmake, even in the face of increasing evidence about both the ecological costs and the political economic costs of such an activity. My second site then is to move away from encounters of international law with other legalities to how multiple legalities operate within international law. And here I draw on my previous work on strategic treaty conflicts, which had sought to track how states, and especially powerful states, might use bilateral or small group treaties as a way of challenging or changing multilateral legal regimes. What I tried to show was two things. One is, of course, there are circumstances in which such an action is ineffective. The contending legality is simply not recognized. It vaporizes into nothing, as if it didn't exist. Most often you see this where the actors that were trying to use the contending legality lacked muscle. So one example is the Bogota Declaration of Equatorial Countries, which tried to challenge a certain idea of outer space that was put in place by the Outer Space Treaty. The reverse, of course, is situations where the contending legality is successful. It is able to unsettle a consensus and to reforge it in a direction that is closer to the interests of those who catalyzed the conflict in the first place. And here I use a number of examples in my work, but the one that I focus on in the paper is the India-US nuclear deal of the early 2000s, which was an agreement between the US and India to cooperate in the exchange of nuclear fuels and civil nuclear technology. India was seen as the main beneficiary of this deal because it was being sort of given access to materials and to technology that it had been denied for many years. But actually the deal worked specifically in the interests of the United States, in that it did a lot for the US by shifting the underpinnings of the nuclear governance regime in directions that were favored by the US. So it shifted the emphasis of nuclear governance away from the underpinning multilateral treaty, the non-proliferation treaty, to a melange of standards and norms that were sort of some soft norms, some particular standards, things that were more amorphous and therefore the US could leverage better. It shifted the focus away from the Conference of NPT parties as a decision-making forum to the Nuclear Suppliers Group, an informal club of states, essentially a bunch of quite well-knit, powerful states. And it shifted the emphasis away from proliferation actions to actors, allowing therefore different standards to be used for favored countries like India, but unfavored countries like Iran. The other examples that I develop in the book are with vis-a-vis the Rome Statute and the UN Convention on the Law of the Sea. The third side of my walking tour is then a different location. This is now not how international law encounters other legalities or multiple legalities within international law, but how the same legality might be experienced differently by different actors depending on their location. So here, the examples I use are examples that speak to how different actors might construct or experience the freedom of the sea. On the one hand, you have something like the Seasteading Project, which is a project of Silicon Valley billionaires to construct or threaten to construct offshore habitats in the hope of getting away from the governance regimes of their home states. So the idea is that they'll build these mini platforms, these what they call mini cities on the open ocean, and these mini cities will be out of reach of states. They'll be out of reach of what they call the cliched or hoary political systems of the states, and will therefore provide these sites for innovation and for experimentation and so forth. There are many contradictions in this project, but it does speak very clearly to how Silicon Valley is able to construct for itself a very protean notion of the freedom of the sea. Protean in the sense that on the one hand, they're able to read into it all sorts of freedoms to be, freedoms to extract the ocean's resources, freedoms to use the openness of the ocean in multiple ways, but of course, also on the other hand, to be able to contract in as needed into the protections of law and the linkages to global political economies to the extent that those enable the seasteads to function. The seasteading project presents statelessness and itinerancy as utopian idols, and I think we already see very much the double stances. We know very well for whom things like statelessness or the ability to, or this sort of constant movement appear as sort of utopian idols, and for whom these are exactly the conditions of their oppression. I juxtapose in the paper seasteaders with groups who are often made the targets of clamor against the freedoms of the sea. So there has been a lot of concern in recent times about IUU fishing, which is illegal, unreported, or unregulated fishing. And these are all activities that are seen as problematic because they essentially result in overfishing. They threaten the fragility of the sea, its ecosystems, and of its resources. Now, of course, these are activities that need to be thought about seriously. But as I point out in the paper, often the focus of the critique tends to be placed on particular kinds of actors, and sort of deflecting from larger patterns or larger structures. So one of the examples of the kind of actor targeted under IUU fishing is a boat like Thunder, which was sunk a few years ago. Now, Thunder was a ship that was Nigerian flagged. It had a Chilean captain. It was crewed by Indonesian sailors. And it sank after a months-long, very historic chase by Sea Shepherd. Sea Shepherd is a group that many of you might know. It was once thought of as an eco-terrorist. Some of you might have seen those photos where Sea Shepherd was protesting at The Hague during the time that the whaling case was going on. It was regarded as a violent actor because it used to ram whaling boats and other kinds of ships that were conducting fishing activities in the ocean. But Sea Shepherd earned its stripes of respectability by this chase. Here, it got the commendation of the Interpol. It had cooperation from a bunch of corporations that were angry about the fishing activities of this one Nigerian ship. And so it turned into this sort of conservative enforcer of international law away from the eco-terrorist it used to be. Meanwhile, the focus being placed on Thunder was taken away from broader questions. Why does illegal fishing take place in the first place? What is the law that actually enables boats like Thunder to get onto the open oceans, including flagging practices, including practices of insurance, including a whole melange of legal norms that are necessary in the first place to bring a ship or a fleet of ships to fish on the ocean. So it takes attention away from these kinds of issues to these sort of aberrational actors who are seen as abusing the freedom of the sea. Again, the contrast with the seasteading project could not be more obvious. Similarly, you have to think about how unregulated fishing is thought of. So unregulated fishing, as Andrew Sadi has pointed out in his wonderful work, is often assimilated in the discourse, at least, exactly to illegal fishing. Actually, it's not illegal fishing. Unregulated fishing simply means fishing being done by under the flags of states who are not specifically part of regional fishing organizations, but that have the right to fish under the general principle of the freedom of fishing in the oceans that is guaranteed by the UN Convention on the Law of the Sea. So the refrain is that these states, if they want to continue fishing, should join a regional fisheries management organization and fish according to its standards and norms, which is all very fine, except that the attention gets taken away from why these states don't join these organizations. And that is usually because, again, the principles on which these organizations work tend to reward those who have longer histories of phishing and not so much those who are seen as new entrants. So there's a whole political economy of rewarding those who've always had the ability to extract the ocean's resources while denying the same opportunities to those who are now developing those abilities. I mean, I could go on with many more examples, but I'm going to end here just with one final point, which is that for those of you who looked at the paper will have seen that the paper uses a set of images. And this is really an effort to use some spatial metaphors to think about these practices of encountering and navigating legalities in international law. The images I use are of mangroves, of the Suez Canal, and of currents, each of these are places that are historically constituted by the encounters of different legalities, but also as images speak to the different ways, these three different situations that I've been describing: international law's engagements with other orders, multiple legalities within international law, and the same legalities washing over different actors differently. So I'll stop here. Thank you very much.
Fascinating. Thanks, Surabhi. I particularly like the visualizations and the images, which I think can help us to see things that otherwise we have difficulty expressing. All right, so thanks to the three of you, really, for kind of a fascinating overview and panoply of different engagements. I think it's brought up all kinds of questions about how this navigating works, who benefits from it, and in which sides. I'd now soon kind of like to open up the discussion, and I'd like to remind everybody kind of how this works a little bit. I mean, we're all now Zoomers, I think, kind of almost naturally, but Zoom also updates from time to time, just kind of to make you aware, kind of there's this reactions button through which you can raise your hands when you're if you're on the Zoom call. For everybody on the live stream, please use the chat function on the live stream to ask questions. They're going to be relayed to me, and I can then post them to the panelists. So please, hand raising or chat function, whatever. Please get us your question. Now, maybe one question from my side to start to the three panelists, Julia, Balakrishnan, and Surabhi. Obviously, kind of you paint pretty different pictures, and so some much more sort of hopeful, and others much gloomier, really, about the possibilities that inhere in this multiplicity. And I was wondering, kind of, is this something that has to do primarily with the sites in which multiplicity is being dealt with, invoked, being processed? Because to some extent, kind of, Balakrishnan said, well, so it's much more difficult in domestic settings that are kind of more prone to centralized sovereignty these days. Kind of there's a push towards that, and there's the global institutions that kind of enable possibilities. In a sense, in Surabhi's, it was a bit more kind of the unstructured sites of contestation, kind of, say, around the oceans or so, that might foreclose certain possibilities. So I'd like to know a little bit from you, kind of, can we say something about where possibly this multiplicity gives rise to more opportunities and possibilities for the counter-hegemonic action that Balakrishnan describes, for less powerful actors to make their voice heard and can become audible or visible? And there are others where we can say, well, that's less the case. Can we get at the question like that? Because it seems to me there's really kind of a contrast in perceptions about what this multiplicity can bring. Does anybody want to respond to that? Julia, Balakrishnan, and Surabhi.
Julia, if you want to go first, I can follow.
I'm not sure I want to go first. I'm not sure I have an answer already. I'm not sure we know enough already to absolutely establish the pattern. I mean, my research is always engaged with very asymmetrical relations in conflicts, whether on the small scale or in more transnational litigations. And this is where I got the sort of more pessimistic impression. But I do, with the sort of notion of the relational coherence, I do take into view more or less successful counter-hegemonic moves, and something at least my PhD students would always associate maybe with the sort of possibilities of a counter-hegemonic voice. I have recently written an article with Philip Dunn. I mean, so it was also an interdisciplinary approach. And here we also discussed, what are the grounds for such alternative normative suggestions to actually gain ground, to gain authority. And particularly for such counter-hegemonic moves, we sort of chose the term charisma and the charismatization of certain normative suggestions. And that again seemed to depend on the one hand on the possibility also to connect to even extra legal discourses and norms that could be mobilized. But of course, it relates, as I've briefly mentioned also in the paper I've uploaded for this conference, to sort of the figurations in which these mobilizations take place, and how alliances can be created. So I think the possibilities for such hegemonic voices to succeed are really quite situational and involve a lot of factors that one needs to look at. And there is not a sort of a general given possibility that is created by multiplicity as such. I think multiplicity doesn't create these possibilities in itself. It can go otherwise. And this is what I wanted to point at with my notion of singularization, because I think that is moving into another direction. And it is actors who hold a lot of, a lot of power, economic power, and also social capital, so to say, the right social capital, who will succeed in these matters or in these processes of singularization. They can determine what norms they pick and choose and where they become significant in what conflicts.
Yeah, I mean, I could just add briefly that I think the main issue I would emphasize when responding to Nico's question is that there is nothing inevitable about the engagement of these actors with multiplicity, or they're not assured of a particular outcome. It's often a shooting in the wind, really, because often the way movements engage with the law is with not out of a matter of choice. It's not comparable in any way, for example, to forum shopping or anything like that. It's more because their backs are against the wall. They're often left with a series of bad choices, one of which involves accessing or engaging with a particular legal forum or advocating for a particular legal norm. And you often find that that's what they end up doing. It doesn't really make anyone happy within these movements themselves, but often they're left with no choice in engaging with many of these. But often what I find with movements engagement is that I think it may be useful to sort of adopt more of a longer view, a longer durée perspective when it comes to movements engagement with the law. If we take movements engagement with the law and multiplicity of law as simply an episodic encounter, which we judge by whether or not a particular advocacy of a movement outcome, for example, the Declaration of the Rights of Indigenous People, whether a particular set of compromises had to be made for ensuring the passage of the particular declaration. And therefore, we make actually an assessment about whether the engagement by these particular actors, is in fact, problematic. We cannot see them as a hopeful sign, but instead should see them as a kind of a compromise in some way. What I would say is that often taking a longer view about movements engagement with the various sites where law gets talked about and produced and managed within the different scales at which we find international, transnational, and national laws, other forms of laws, non-state orders, interacting and intersecting with each other. What we actually often find is that engaging with a particular episode, for example, getting a particular instrument adopted, is part of a longer strategy or longer process of engagement, which might open up doors for either that particular movement or other movements to achieve their goals. So to give you a specific example of what I mean, the adoption of the voluntary guidelines on responsible governance of tenure in 2012 is one of those soft law instruments which have emerged in the area of food security and food sovereignty, which has actually had a significant impact on practice over the last, 8 years since it was adopted. And if you look at the process that led to it, it was a result of a complex process of multi-stakeholder negotiation, including, of course, several representatives of governments and other actors, member states of the FAO, other stakeholders. But 2 years after the adoption of the CFS, by the CFS, of the voluntary guidelines on responsible governance of tenure, another intergovernmental committee of the FAO, the Committee on Fisheries, adopted the voluntary guidelines for securing sustainable small-scale fisheries in the context of food security and poverty eradication. I mean, these guidelines were the outcome of a long participatory process as well, conducted between overlapping years, which also led to the adoption of the VGGT 2010 to 13, I think, involving, again, thousands of representatives of small-scale fishers, fish workers, their organizations, researchers, development partners, and of course, thousands of representatives of governments at different scales, not just at the national level, but different line ministries and local officials. And I think, this is typical of the sort of process that evolves at the global level. So it's not to say that if movements remain engaged, more opportunities would somehow miraculously open up somewhere. I'm not saying that at all, but that often you find that, in fact, it's actually a longer sort of perspective that we need to properly assess, which actor is engaging for what purpose and what do they get out of it.
Thanks. So, Ravi, you wanted to come in on this? Are you muted?
Yeah, just briefly to say, I think maybe a couple of things. Firstly, I think there's actually a lot of common ground between what all three of us have been saying, in the sense that, firstly, not seeing multiplicity itself as necessarily creating or not creating opportunities, but saying that the focus has to be on other things. But more than that, I think I agree with, so this is why I said I'm moving my focus away from actors to patterns, because I very much agree that there is only certain that for actors, and particularly third world actors from the global south, you have to engage in terms of what is available to you, right? You engage with your backs to the wall. You work within the systems as you find them. You create opportunities. You're on the wing. And as Balakrishnan rightly pointed out, you sort of keep chipping away at the system in the hope that that the very act of your movement will in time extract more and more sort of or be able to make further and further inroads into what is essentially an oppressive order. So I think all of that is well taken, but I think it's important also where we might differ, the three of us, is of course what discourses we are reacting to. And my paper really, at least, is about saying, well, we have to, yes, we should look at actors, but it's important also to turn the gaze sometimes not away from subaltern actors or global southern actors, to also turn it critically onto the system itself to think about the ways in which the system responds to these efforts by these actors. So some of the narratives that I find difficult and that I react to include the narrative of the epiphenomenality of international law, because that sort of assumes that international law can be made or remade according to preferences, when in fact the reality of international law is that it is much more viscous and therefore harder to form or reform. Similarly, the discourse on lawfare, which is an important discourse because it talks about how the law is instrumentalized in oppressive ways, but again, tends to suggest in the ways in which it describes law is that the law becomes amorphized, right? So it loses form. Everything can become a reflection of international law, that hard law gives way to a greater melange of legalities, which includes soft law. But in fact, we know that these relationships are again not as fluid as we think they are. There is a lot of viscosity in terms of laws that have an effect on people's lives versus laws that express hortatory standards but don't end up having those effects. So keeping in mind the viscosity of law, the gaze then has to be on factors that help, and Julia rightly pointed to these, right, that help people navigate more or less effectively. And these come back to money, power, control over material systems of knowledge production that help you to qualify what you're doing as juris generative as opposed to illegal, and so forth. So, and this is until we start thinking critically of the ways in which international law finds ways to consolidate itself against challenges to it, we're only doing half the work, because we're putting all the emphasis or all the burden on actors to navigate the system, but not really looking at what the system does to sort of control or minimize these opportunities for navigation.
Yeah, thanks. In a sense, kind of the skewed playing field that actors already come to when they try to engage. Thanks a lot. I have Julie Wetterslev and Hannah Böckenkötter as with questions. I would take the two together and then give you a chance to respond unless somebody else has a question right now. Julie.
Yes, thank you so much for these wonderful presentations. I just wanted to respond or comment on what Surabi mentioned about this subsumption of alternative legal orders into a more hegemonic or dominant order, because this is also something that I have observed in my work with indigenous communities in northern Nicaragua, in this process of titling land as indigenous communal territories, where there was really a perception and in many ways a lot of hope that this could be forging a sort of new and more intercultural order relating to land and territory. But in fact, considering that whole process in a perspective going a bit backwards, it's sort of obvious now that these communities have been absorbed into a logics of property holding and market transactions, sort of contrary to this idea of inalienable land that was going to be taken off the market. And at the same time, this kind of logic of territory has also reproduced the sort of bureaucracy and management and paper load of the modern bureaucratic state, so that these communities are, for example, now elaborating constitutions for their territories, and they are changing the governance and authority structures so that instead of just being chosen for 1 year, the indigenous leaders are now on election for 4 years at a time, because that's the only way you can really get the hang of how to be a leader and so on. So I really see a lot of subsumption where there was an expectancy of, a resistance to the state order and logics. So it was just to complement with another example in that sense.
Thanks. Hannah?
Yes, thank you very much for really 3 very inspiring presentations. So I would like to build on something that Balakrishnan Rajagopal said. So in your presentation, you said that really what is necessary is counter-hegemonic contestation. And then in your first answer, you mentioned 2 new instruments in the realm of tenure security, both being soft law, as you said yourself. And so that led me to think there are really 2 different ways I would argue that that counter-hegemonic contestation is possible. One is at the level of content, so you can challenge substantive content as it is through the introduction of new instruments. But then the other possibility of challenge might be at the level of what counts as law. And that is something that I would like to ask all 3 panelists, to what extent sort of like the way in which not only the content is challenged, but also the form through which it is challenged matters. So we know very well from scholars like Tony Angie that there have been attempts to challenge the content through a particular form that was then not recognized as law by the hegemonic forces. And that is something that's sort of the relationship between form and content is one that interests me greatly. So I'm wondering to what extent it is possible for actors to challenge not only the content, but also what counts as law in its form. Thank you very much.
Thanks, Hannah. Unless there's someone else now. Julia, Balakrishnan, and Sorabi, we have a few minutes left for your answer, so please, whoever likes to.
Well, I find this a very important question, but it sort of sidelines maybe a little bit the pattern that I seem to be observing, the pattern in the sense of Sorabi's recommendation, because it seems to me that even when other norms are accepted as law or sort of tolerated, law plays has a lesser significance in that, and that is the process, of tribunalization, in which the singularization happens, and it seems to me increasing everywhere. And it's really something that Laura Nader, another legal anthropologist, pointed to many years ago, that as soon as actors from the global south succeed in using and employing legal norms and legal procedures, suddenly the standard of civility is ADR, and not really using what was accepted as law, but moving out of it. And there, of course, the relations between disputants, for example, are entirely different, and to my impression are much more dependent on the factors that Sorabi also mentioned. So it's not only a matter of what is accepted as law and whether we talk about soft law or not, but also well, what are the reactions of the system, as Sorabi asked, towards the successful employment of law by novel actors, or by actors who might for long not have employed them so successfully. And this is, in my impression, and maybe I'm exaggerating here a little bit, a moving out of law.
All right, so kind of the creation of multiplicity, really kind of a push away from law. Good. Any of the others?
Just briefly, maybe I was just thinking about this subsumption of into dominant legal orders that was mentioned by Julie, and Sorabi, of course, made the point very eloquently. Particularly the example that was given, the land tenure arrangements being subsumed under dominant legal order, is of course a very familiar story, and I encounter it all the time in my work, actually, now as special rapporteur, and it's absolutely a global problem, a global trend. And I think that while that happens, we have two kinds of questions to ask. One is, um, how did it come to this? Meaning the dominant sort of subsumption into dominant legal orders, has it always been the case, or is it something new, or are there new sort of patterns of subsumption that we are seeing? And I would suggest that, like I said in my remarks, that we are seeing new patterns of subsumption, a new assertion of a kind of a sovereign centralism that, for example, wasn't seen 30 years ago when I first started entering international legal practice and legal work. There's a lot more consolidation of sovereigntism in general. There is a hardening of developmental nationalism, for example, across the global South in a much more hard-edged, glinty way, which wasn't the case 30 years ago. It seemed a bit more open in the early years of a turn towards neoliberalism. I'm thinking of, for example, India, where I come from. It was a very different type of conversation, and the way the different legal regimes interact with each other was completely different. Within the state, there's certainly a trend towards a lot more centralism. But the second question I think we can ask about subsumption is not only how did we come to this, or is current subsumption different from earlier, waves of subsumption, but also, what's driving it? What's the logic behind it? Who's driving it? And I am going to say that at least with regard to land consolidation and land tenure systems, I think it's very important not to sort of oversubscribe or over theorize what we are doing in terms of a singular phenomenon, such as, for example, the logic of capital. So taking kind of a David Harveyan view of everything being somehow the inevitable consequence of something mysterious, a mechanism working out in the background, like neoliberalism. I mean, if you look at the waves of new land consolidation that happened in the global South, most of land consolidation shifted land tenure systems, which were largely in the hands of communities and fairly unregulated, in the sense in which, for example, the unregulated fisheries happens, like Surabhi was describing, until the mid-70s. It was in the mid-70s that much of the global South, particularly in sub-Saharan Africa, consolidated all tenure systems to be in the hand of the state. So there is a logic of the state that coexists with the logic of capital. And when one recedes and one follows, when one logic actually happens to sort of serve the interests of the other, logic of the state could well be the logic of capital in disguise, or vice versa. The reverse has also been argued, for example, in the context of state society literature in Africa, that what we often think of as the operation of capital is nothing but a formula for the proliferation of the state, because state making in itself becomes an end for the consolidation of particular group identities, for example, ethnic or tribal or other identities. Capturing the state is a matter of life and death for them. And often, the logic of the state overwhelms the logic of capital, or logic of capital has to subserve the logic of the state. So I would kind of I wanted to say this in response to the subsumption issue. Thank you.
Yeah, just maybe briefly again, two quick points. One is this interesting point that Hannah made about the relationship between form and content. And I think some of what you say resonates very much with me, but at the same time, one of the things I've been interested in is how form gets qualified as being that form or not, depending on the content and who's doing the work of trying to place their interests into that form, right? So strategically created treaty conflicts was about which contending legalities get recognized as equal treaties that deserve respect within that deserve the protection of the international legal system's general respect for treaties, versus which actions get sort of dismissed as, oh, well, that's not quite really saying anything that is legally binding, or that's anything beyond the merely hortatory, which is something like the Bogota Declaration. So for me, it's interesting that the qualification or disqualification of things as legal forms depends on A, who's promoting them, and then B, of course, what logics they're speaking to, and the extent to which, therefore, they are seen as merely an expression of what is already recognizable as the legal, or what is outrageously outside of the sphere of the legal. The second thing I wanted to say was, and this is really just to say that what Julia was saying about the ways in which the system sometimes, the moment at which an actor might try to use multiple legalities or might try to reach a space where they try to reach a place of reckoning with the legal system, the system might itself move away from formality to informality or find other ways of sort of diminishing the achievement. This really resonated with me. It made me think of Patricia Williams' work on how informality is then sometimes used as a way of sort of it's restricting the scope of activity of actors, and she talked about particularly the African-American actors who try to use things like the formality of contract or the formality of property law to their ends, and then they're told, oh, well, we have to move beyond these kinds of very formal arrangements to think about the informal codes. So it's this sort of who gets to move nimbly through both formality and informality and use both to their ends versus for whom both become constraints is what she was writing about in her work. And thirdly, I really like this point about the logic of the capital being sort of intersecting with the logic of the state, with, of course, the one question being how, again, the role of international law and the extent to which international law and the ways in which it allows the logic of the state to be given expression, how often does that depart from the logic of capital? And that's, I think, a question that, again, is an empirical question, not necessarily one that can be answered in the abstract, but there is a case for suggesting that international law best allows the logic of the state to be expressed when that is also an expression of the logic of capital, because then, there's no real, that sort of reinforces already the structures and the normative commitments of international law, rather than vice versa.
Thanks, Ravi. Thanks to all three panelists and everybody participating. So that was really fascinating, I thought. I'm not going to try to summarize this. I thought there were so many interesting points. One thing that struck me really overall was that the whole kind of relatively tried and obvious description of law as process somehow gains quite a different significance in these descriptions that you've given, and that kind of this process of law really is one that seems to be fragmenting the law in a much deeper sense than international lawyers keep talking about fragmentation, but fragmenting it really into all kinds of different pieces and engagements, in which kind of the law as such seems to be only kind of a pretty hollow invocation, but it is really about gaining ground on particular terrains, and particular struggles, in which using and invoking certain norms might be helpful. But as some of you have pointed out, right, once you've invoked them and once you've gained on their grounds, right, the ground might be slipping away already in another direction. And the law as a frame for action, kind of as we might have imagined it, is somewhat much more ephemeral and not graspable. All right, we're going to continue with these kinds of questions, but it was a fascinating first panel, I thought, that's given us a lot of food for thought that we can digest and kind of repurpose again in the coming panels. So now we turn in the next session to 3 parallel panels, colliding systems or legal tapestry, post-colonial legal encounters, and weaving the law. So for those on the Zoom call, everybody they all have different Zoom links. Please click on whichever one you want to go onto. Likewise, on the live stream on the Verfassungsblog, you'll find different places to watch the live stream of each of them. And please don't forget to send your questions and raise your hands in these different sessions. Something else I was meaning to say, it might have already forgotten about it. Yeah, one thing, maybe the panelists could be on the call like 5 minutes before the scheduled time. I think will be helpful, so we can sort out the technicalities and make sure everything is working ahead of time. All right, thanks to all. See you in a moment.